Welcome, everybody. My name is Marty Mascari. I am a contractor with the North Central Texas Area Agency on Aging and the North Central Texas Aging and Disability Resource Center, or ADRC. Um, we are blessed here to have our partners at Heyman Hope here to talk about my loved one past what now. But before we get to do that, we're going to talk a little bit about CEUs. And if we could advance the slide one, that would be great. Yes, for those of you that may not have joined us before, we have complimentary CEUs for licensed social workers and licensed professional counselors in the state of Texas. If you have a different license in Texas or you have a license outside of Texas, please um, feel free to go through the process and get a certificate. And you can share that with whoever your jurisdiction is. But please know that there's no guarantee that they're going to take it. That is totally up to them but these two jurisdictions in Texas are who were set up to do. I don't know, is today approved for CLEs, Sheila?
No, because I didn't get it sent in time.
It's all right. I just didn't know, and I wanted to add that if it was. It's not a problem. That's why I was asking. No problem. So today's presentation is worth 1.5 hours of CEU credits. You must complete the entire live webinar until the end of the scheduled time. You must also complete the Google evaluation survey. At the end of Zoom, when you close out, it should say, would you like to take a short survey? That will lead, if you go do that, that will take care of that is the Google survey. But if not, you also receive that in a follow-up email that will go out before the end of the day tomorrow. And so if you would please note that we want you to complete that by the end of the day next Friday, 8/2, and give us about 4 weeks to get those certificates out to you. Sheila, I'm going to let you introduce Fred, if you would, and we'll get rolling. And just to say two things. Number one, if you have any questions for Fred, if you'll please put them in the Q&A and not in the chat, because it's just so much easier to find that, to get at them if they're in the Q&A than filtering through all of the chat. And then I'm sorry. I am still working on the link to the slides. As soon as I have them done, which will be just a few minutes, I will put them in the chat for you all. Thanks. Sorry. Thanks, Sheila.
That's okay. Well, this has just been quite the morning already. Yes, I've had sketchy internet over here. And then when I did send it, when Marty did receive what I sent hours before, it was the wrong, it was the wrong piece. So I had to resend it, and he just now got it, folks. So all of this delay is my fault. So just blame Sheila for all of this.
We usually do.
Yeah, really funny, Fred. Yeah, Fred does anyway, but So anyway, okay. I am Sheila Williamson, the Director of Community Services with Heyman Hope. Fred is my boss, and he has been for 7.5 years, and we've known each other longer than that. Fred is the founding partner of Heyman Hope. And now we have 3 offices, like we just talked about. The newest one is in Sherman. But we today are not here to talk about Heyman Hope. We are here to educate you, which is actually Fred's favorite thing to do. He loves educating more than he does anything else. So we're going to talk about a subject that people don't like to talk about, but is very necessary and will happen. You will be faced with this. Every single person will be faced with this. So this gives you an overview of what will happen, what needs to happen, and ways to do it efficiently. So without any further ado, my boss, Fred Heyman.
Well, thank you, Sheila. And yes, thank you all for showing up today, because this is not work for me. So thanks for getting me out of work. I absolutely do love to educate. I love to speak. I hope that I will give you something today to really think about and that you can use. I'll be honest, I'm not ever crazy about having to get continuing legal education, because a lot of times it's just a waste of my time. And I feel like I have to sit there for an hour, hour and a half, just so I can get the credit, but I don't get anything out of it. And so I try my very best not to do that in this class. You're going to get some credit, but hopefully you're also going to get some information that you can use, or you can pass on to your family, or you can pass on to your patients or your clients, and things that we may not always think about. What I tried to do with this presentation is take it beyond just legal. Now, we are going to talk about the estate administration process and what is referred to as probate. Most of you all have probably heard that term. A lot of people don't really understand what it means, but this is the process when somebody passes away. And like Sheila says, we're all going to deal with it. If you haven't dealt with it already, most of you all probably have. And some of you all, if we could go through everybody and talk to everybody on this presentation, you'd tell me how horrible it was. Some will say how smooth it was. It all depends on how organized really the person was who passed away, and how dysfunctional the family is. Because you want family dysfunction, pass away and leave some money, and we have tons of family dysfunction. So this class is going to try to help walk through all the things that we need to think about, so that for us, we should put all this together so that we don't leave a mess for our family, for our children, for our spouse, whoever is important in our life. So let's get started. What does the term administration of an estate mean? In theory, administration of an estate is simply collecting the assets of the person that passed away, managing those assets and the debts, determining what the debts are, and distributing them to who the person says they go to. So there are different ways that happens depending on whether a person has a will, depending on whether the person doesn't have a will, and depending on whether the person sets up a trust. So the Texas probate process is determining whether a person has a will, and if it's a will, the will is proven up. If there is no will, we do what's called an heirship proceeding, determining who the heirs are. When we look at the person's estate, and when we look at the documents they have, I want to cover just for a few minutes what I call the living documents, a couple of the living documents that we deal with, because we have a lot of problems with this, people thinking that these documents survive death, and they don't. The first living document is the medical power of attorney. The medical power of attorney gives people the authority to make medical decisions for the person while they're alive. That medical power of attorney does not carry into death, and it does not have any authority in death. So some people think it allows you to get medical records, it allows you to talk to doctors after the person passes away. The medical power of attorney does not give that authority. It is only good during lifetime. The other one is the advanced medical directive. The advanced medical directive is a different document than the do not resuscitate document that people quite often refer to, or DNR. And what the difference is a DNR is in essence, if it's, again, these need to be properly written, because I have people refer to a DNR, and then when I read it, it's actually an advanced directive. So a properly drafted DNR says, don't touch me. Don't touch me at all. No matter what, don't bring me back. If I have a heart attack, don't give me CPR. Don't shock my heart. Let me go. Now, DNRs, typically, I only do those for two categories. Somebody who is very, very old and is at that stage that says, I don't want any measures. I've lived long enough. And people that are on hospice that have been fighting a disease, and it's a terminable disease. And they say, well, if I have a heart attack, I don't want to go through this anymore. Everybody else we do an advanced directive for. The advanced directive is where we say, I want you to do everything in your power to treat me. I want you to do everything in your power to make me well. But if all that's been exhausted and there's no other choice now but sustain my life on a machine or let me go, I choose while I'm well which one I want. And so I choose to pull my plug or not at that point. And again, that document is only an end-of-life document, and it does not go beyond death. The other one is the HIPAA document. The HIPAA form allows you to get medical records and medical information. Now, there is a conflict about whether this form goes beyond death, but it legally doesn't go beyond death. Sometimes they will honor it and they will still allow you to get things, but they don't have to. So the HIPAA form, again, is the only document during life while the person's being treated to be able to get that information. And then the last one is the Declaration of Guardian in case of future incapacitation. This is the document where I say, if I become totally incapacitated, who would I want to be my guardian? Who would I want the legal person to take care of me? The great thing about this form is it not only allows you to name your guardian so that the court doesn't, and so family doesn't fight, but it also allows you to name who you don't want your guardian to be. So if there's troublemakers in the family, or if there's people you don't want to burden, you can disqualify them on this form. But again, it's only good during life, because misconceptions that I have, number one is that you can sign documents when you're legally incompetent. Legal incompetency does not allow people to sign documents. And I'm going to put a hold on real quick because Sheila, I'm afraid we are not on the proper presentation. I'm going to back out just a minute because we're going too much into the documents and not into the presentation that allows us to go through the administration process. So if you guys will give me just a minute, let me see if we can fix this. And if I can, I don't want to go too deep into this presentation on all of the estate planning documents when we really need to go into the administration process. Yeah. So I'm going to back out really quickly.
I am here. I'm trying to see what
Yeah. And the reason I'm seeing that I think we're on the wrong presentation is because of I just gave this the other day, and this is not the one that I did.
okay.
So we may have to send this
just
to you, and let's see.
can you let me do this. Let me
Yeah, okay, so let me did you unshare the screen?
I did not unshare it. I all I did was turn on my mic so I could talk. Can you hear me?
I can't hear you. Can you see
I'm scrambling
my
to
screen or not?
I can hear you, yes.
Can you see my screen or no?
No.
Okay, let's
see
try
you.
this. Can you see it now?
Yes, but unfortunately it's got the logos on there. I know that's,
And we may have to go with that because
yeah, this is totally different. You're right. This is totally different.
It is different than when Sheila, could you send that to me so I can
I would if I had it.
oh
I sent you the one I had, which is a PDF, because that's the one I used to.
Yeah, hold on just a second, Marty, and I'll send it to Sheila. I'm sorry for the delay, y'all. We will get
that's
this
all right.
fixed.
We'll be just fine. I'll just fix the link to match up with what you're using and so that I
also
get people the right slide.
Marty was asking me that checklist that I just sent him. Have we updated that 43-point checklist? I don't think so. I think it's the same one. Yeah.
No, we have not.
So it's the same one, Marty. Yeah.
Yeah, just and so I'm gonna make the link for that too. We just believe it or not, we had somebody that had attended a couple of years ago this presentation you did, and their loved one had just passed and they needed the list.
Yeah.
I mean that was
And
just in last week.
and there's two people, Tracy and Melinda, have had people pass, family members pass just recently.
Yeah.
And so they're asking for it too. So I told them in the 43 things, just while we're waiting for this to happen, the 43 things, some of it is self-explanatory, like, you know, ordering copies of the death certificate, but you'd be surprised at how many people that do not know. They're calling us to ask how many copies you need. For example, you get as many as you can. I'll be honest with you there. After going through this, you get as many as you can. But I mean, there's all kinds of things that Fred has on there that I didn't know either. So some are self-explanatory, but others are not. So these are going to be important for all of us to know. I heard this again Friday and learned it. So, okay, I'm going to send it right now, Fred, because I got it.
She just emailed it to you.
Yeah, I'm
if
sending it to Marty right now.
If
Yeah,
the
and
screen is on, we've got the right presentation on finally, and I think we can move forward.
Marty, I
go
just
for it.
sent it. Yeah.
Go for it. Thank you.
Good to go? Okay, so I apologize for that. It took me a couple slides. It didn't look familiar, but it wasn't some information you couldn't use. But let's jump right into what exactly is administration. When we start talking about the administration process, I've broken this down into different stages. The first stage, let's look immediately following the death. Right after the person passes away, what are some of the things that we need to concern ourselves with? First one is this person an organ donor? Is there a reason we need to make arrangements for organ transplantation? This is crucial because timing is of the essence when it comes to organ donations. Now, when you say on your driver's license that you're an organ donor, that pretty much leaves it wide open. We recommend that our clients do an anatomical gift form that really says what they want. Do I want to donate my organs for transplantation purposes? Will I allow my organs to be used for therapy or for experimentation? Do I want to donate my entire body for science or for medicine? So it's really important that you know as much as possible when the person passes away of what they exactly want. There's arrangements for transplantation of bodies. I get calls all the time. My dad just passed away. Who do I call? What do I do? He passed away at home. We were not at a hospital. The hospitals will make arrangements. If you're expecting the death, if there's issues that are leading up to the death, you may have already notified a funeral home. But if not, the county mortician needs to be noted and the morgue is notified to come transport the body. Locate and inform families, friends, acquaintances, all the people that need to know. That's important because if you just kind of flying by the cuff, you almost always forget somebody and you're going to hurt people's feelings get hurt. So having a good list of people of, okay, when you pass away, and this is, we always kind of think of this as morbid, but it's really not. For me to put down, when I pass away, these are the important people I want you to contact. Beyond that, okay, you can contact who you want, but these are the people I would like notified at the time of my death. And there's nothing wrong with making those lists and keeping that organized for your family. Locating primary care doctor if needed, because sometimes the primary care doctor is the doctor that has to pronounce death. Arranging for care of dependents, if there are children or if there are special needs individuals, that is quite often an issue. And pets. People don't think about, well, when I pass away, what's gonna happen with my dogs and my cats? And if you're like me, I've got miniature longhorns. Who's gonna take care of those? So any type of animals that I'm responsible for, the person that passes away is responsible for, those need to be cared for. And securing the dependent's home. I had a situation in El Paso years ago where a person passed away and that lady, she was 102 years old. All of her family lived in Mississippi. They called me in a panic because they were afraid that the house was going to be broken into or that people had keys to the house that shouldn't. And so I went up to make arrangements with a locksmith to change everything. While I was in the process of doing that, I hear sirens because one of the neighbors called thinking I was breaking into the house. And here, next thing I know, police cars come flying into the driveway. Luckily, I was a former El Paso police officer. I knew them when they pulled in. The first guy gets out of his car and he looks at me. He says, "You don't look like a burglar." And I said, "You're darn right I don't." And they called everybody off. But it was a mess that shouldn't have been happened because there was no arrangements made prior to that to secure the home. After immediately following death, now what do we want to look at?
Fred, can
Yes,
you
ma'am.
change it to presentation only because you got the slides over on the left side?
Oh, let me see. How do I do that? Let me see.
I don't know, can you see where it says slideshow? And then you want to start from the current slide. Well, that's right. Go to it.
And we
Sorry.
go,
You're right to the beginning, but that's,
okay, yeah, let me just go through real quick. Is that better? All
Yep.
right,
Yes.
okay. Pre-funeral, we need to locate final expense insurance policies or pre-need funeral plans. What is the difference between those two? Pre-need funeral plans have already spelled out exactly what I want done when I pass away. It may have already paid for everything, including a casket, may have picked out all that. I highly advise that people talk to funeral homes. I think one of the biggest ones is Dignity in the area, Dignity Memorial. There are some family-owned ones. But anybody, you know, that sells and does funerals can do pre-need funeral plans. The difference between that and final expense insurance is simply an insurance policy. Usually they're $10,000 or somewhere around there, and they don't get to you immediately. So I'm not a big fan of final expense insurance because most of the time the family has to put out of pocket to get the funeral done, and then they get reimbursed by this final expense insurance because it doesn't happen immediately. There are some funeral homes I've heard that will take that final expense. So in essence, they'll do the funeral without out of pocket, and then the final expense insurance pays directly to the funeral home. But I don't know how exactly that goes. They go about doing that. But you need to make sure and see if the person has that. Locate the important papers, birth certificates, military papers, marriage license, social security, all of these things that quite often if we're honest with ourselves, we don't keep organized. We don't keep in a binder or in a certain place so that if something happens to us, people can easily find that. I made the mistake of volunteering to be an executor years ago for a very good friend of mine who his wife had passed away, and we redid his plan, and he begged me to do it. And my policy was that I don't serve as executor or trustee for my clients, but he didn't have anybody. And he said, if Fred, if you don't do it, my family will fight. If you do it, they won't. And he was right. By me doing it, there was no family fights. We were able to take care of it, but he was so unorganized that it literally took me 3 years to administer his estate because he had stocks and bonds and investments that I had to hire companies to track down things. I got a phone call one day saying, oh, we found some stock. I don't know how much it's worth, but it's with Enron. And we both start laughing, going, yeah, the paper is worth more than the stock. But so being organized is crucial when it comes to helping your family after you pass away. You need to file insurance claims if there are insurance issues that need to be dealt with. And most importantly, veteran. If there are veterans benefits, you need to know ahead of time what those are. There's a lot of organizations in counties all over the United States that their entire job is to help people know what veterans benefits they have. So contacting one of those agencies is very, very important. Now, what about at the time of the funeral? Have you ever thought about writing your own obituary? A lot of people think that's very morbid, but in reality, who knows you better than you? And who knows you better than what you would like told to people than you? And so writing your own obituary or even outlining it and doing bullet points can help families. When my dad passed away in 1995, my dad had pancreatic liver cancer. He was given 6 months to live and died in 6 weeks. When he passed away, I was in the middle of law school. And I came home for the funeral, and I was asked to do the eulogy. And I'll be honest, when I was asked to do it, I was panicked because I was like, there's so much about my dad I don't know. I mean, I know my dad was in the Air Force. I know my dad served in Vietnam, but he was a spy during Vietnam. He did everything top secret, and there's so much about his life that I didn't know. And so I had to put something together. What am I going to say, and how am I going to do this? So helping your family out with that is not a bad thing. It's a really, really good thing you can do to help the family carry these things out. Carrying out the funeral arrangements and the headstone and getting the death certificates, and then just looking at, okay, now that we've carried out the funeral, we now have to start looking at administering the estate. Does the person have a will? Do they have a trust? Did they have anything at all? Oh yeah, I remember Dad talking about a will, but do you have any idea where it is? I hear that all the time. I know he had a will, but nobody can find it. So being organized is key to doing your family right. So what is probate? Probate is the legal process, the judicial courtroom legal process that a person's estate has to go through, whether they die with or without a will. Now, I get the question all the time, does a person have to go through probate? Do we always have to probate an estate? And the determination is depending on what type of property the person held when they died. What type of property did they own? And so the probate process, what we're doing during the probate process is we are determining death, which really sounds funny, but what if a person has been missing for 7 years? We hear those on TV shows like 48 Hours and Dateline about a person missing in their body and they have never been found. At what point is it determined death? And so the court requires us to prove up death. The court also requires us to prove that there's a need for the administration of the estate. What did this person have? What did they leave behind that needs to be transferred from one individual, the deceased, to other individuals? And how do we need to go about doing that? So we usually always have to have at least one hearing when it comes to the probate process to prove up death and to prove the need for administration. Now, what determines probate? Again, what determines it depends on what the person owns. There are really 3 types of properties that will always kick an estate into probate. If there were assets in that person's sole name. So if they had a bank account and their name was the only one on it, and they didn't have a joint owner, and they didn't leave what's called a beneficiary, a TOD, or a POD. And if you've heard those terms, TOD is transfer on death, POD is pay on death, but POD, TOD, and beneficiary all mean the exact same thing. Who is going to get this money when the person passes away? I am shocked at how many cases I've had over the years where a person had a bank account that did not have a beneficiary, did not have a TOD, did not have a POD. I got a call just about a week ago from a lady whose daughter died, and the only asset they can't get access to is the daughter's bank account. And I said, do you have any idea how much money's in there? And she said, well, we think it's about $650. And I said, well, it's not worth the process you're going to have to go through to get the $650. You're going to have to pay me or somebody else more than that to get it. And some counties, you can do what's called a small estate affidavit, and you can do it yourself. But even that costs you the filing fees and the court costs. So you're still putting out probably $350 plus your time. So sometimes it's just not worth it. There are accounts, I've had people call me with accounts and it was, $2,000. And I tell them, just leave it alone and keep an eye on at what point it gets what's called escheated to the state. It gets turned over for lost property and unclaimed property. And typically it's easier to get it once it's unclaimed property than it is to go through the probate process if it's that small of an amount. So sole named items, it could be a house in that person's only name. It can be anything but a vehicle. Vehicles pass outside of probate. So vehicles, the Department of Motor Vehicles, DMV, they have a process where you can transfer a titled vehicle, and titled vehicles include cars, they include trailers, they include even mobile homes. Anything with a title can be transferred outside of probate with a death certificate and what's called an affidavit of heirship through the DMV. So I don't really worry so much about vehicles, but anything else in the person's sole name. The second one is real estate. Real estate is typically held in Texas. And again, you need to check your state to see what the laws are in your state. But in Texas, we hold real estate as what's called joint tenants in common. Meaning whoever is on the deed owns it in the percentage of the number of names on the deed. That includes husband and wife. So if husband and wife own a property and what we term as community property, my wife and I own this house, we've owned it forever. We've been married 30 years, 40 years, 50 years, whatever the case may be. And we're both on the deed. I die. That means it's hers, right? Not in Texas. In Texas, my 50% goes to the grave with me until some legal process is done to transfer it out of the grave. That's called joint tenants in common. We own property in Texas as joint tenants in common, meaning each person owns their percentage and they can do whatever they want with it. So technically, even though I have community property with my wife, if I wanted to give my half to my girlfriend, I could. Now, it's horrible, but in Texas, we can do that. We control our half. And so when somebody passes away, that person's property has to typically go through the probate process unless they own it differently than joint tenants in common, which is very uncommon unless a person has a trust. If you have a trust, you can put it into a trust, and we'll talk a little bit about that later, but you can put it into a trust and the trust doesn't get sick and the trust doesn't die. So assets in a trust pass outside of probate. But if my name is on the real estate, most likely it's going to have to go through probate. And then accounts, and again, don't list a beneficiary designation. So big misconceptions about a power of attorney. The power of attorney, different than what we started at the beginning when I was talking a little bit about our living documents. This is one I didn't mention. The power of attorney is a financial document. It is a document that allows you to take care of finances when somebody is alive. I get the call all the time that says, my dad passed away, but I have dad's power of attorney, so I'm going to get into dad's bank account so I can pay his bills. And I have to tell that person, no, you're not. Dad's power of attorney died when dad died, and you have no authority to get into dad's bank account with that power of attorney. And if you try to, you're committing fraud and you could go to jail. So I recommend you don't do that. So powers of attorney are only good during death. I tell my clients over and over and over, when they'll call me and they'll say, well, I need you to do me a will. Well, you might need me to do you a will, but you also need me to do living documents, because we all need living documents and death documents. And the power of attorney is a living document. The death document, the one that everybody knows about, is the last will and testament. That is a good document. And in Texas, and I think this includes most states, if you don't have a will, guess what? You do have a will, and the state wrote it for you. So if you want to trust the government with your life and your property and what happens after you die, then don't worry about it. And you're going to make me or somebody like me a lot of money, because we make more money when somebody dies without a will than with a will. A will allows you to trump the law and say, this is what I want, not what the state of Texas says, but I want it this way. This is where I want my property to go. This is who I want to appoint to do that. You get to the say so. So the will is good, but it doesn't have benefits during life. And again, if you don't have one, the government has one for you. And it does allow you to give away your stuff. You get to decide who gets your stuff. And again, you have control. You have control of your sole and separate property, and you have control of your half of community property. And you can give it however you want. You decide who's in charge. That person is called an executor when it comes to the will. You can assign a guardian for minor children in a will, but I do not recommend that whatsoever, because a will is really not a will. A will is a wish until a judge grants that wish and turns it into a will. And so in Texas, when somebody passes away, that will is triggered upon death. So during life, there's no benefits whatsoever. It's, as the saying goes, it's not worth the paper it's written on during life. It means nothing. The minute you die, it's triggered, but it's not effective until it's filed into court and the judge grants the wishes. People will say, they'll give me, I've got a will and I'm the executor. No, you're not the executor until the judge says you're the executor. The will says they want you to be the executor, but somebody has to grant those wishes, and that is a judge. And I guarantee that from the time of death until the time you see a judge is going to be a matter of 60, 90, or more days. Now, what if I name a guardian for my minor children in there and my wife and I are tragically killed in a car accident? Now the police are involved and there's minor children. Who else gets involved? Child Protective Services. I was a cop before I was a lawyer. I was a cop in El Paso, Texas for over 5 years. And I saw cases where Child Protective Services came in, they took custody of the minor children, and they said, when the judge appoints the guardian, we'll give you the children back. But until then, we're going to hold on to these children. To me, as a parent, that's the most horrible thing I could ever do to my children. So I do not ever recommend using a will to appoint guardians for your minor children. That's where a trust comes in and works really, really well. You can outline your funeral wishes, but again, I don't recommend that because I guarantee your funeral is going to be over with far before the time a judge sees this document. You can put into the will what's called a testamentary trust. There are two types of trusts, living trusts and testamentary trusts. A living trust is a trust you put into effect while you're alive, and it has life benefits as well as death benefits. But a testamentary trust goes into your will. And your will says, when I die, I want this trust set up for my children. I don't recommend testamentary trusts because testamentary trusts require the will to be probated. And if you can set up a living trust and avoid probate, why would you not do that? So living trusts work far better than testamentary trusts. But I get the calls all the time. Well, I've talked to other estate planning attorneys, and they say all I need is a will, and I can put a testamentary trust in the will because the Texas probate process is real easy. Well, maybe compared to other states it is, but it's still a legal process. And if you've ever been in court, it is not a fun place to be. I've been in court for the last 28 years, and I hate it. I hate going to court, even as an attorney. But when you're the party in the thing and you have to rely on the judge to do things and you have to wait on him or her, it's a process you want to avoid at all costs. So why would an attorney tell you to do that? I have my opinions, but I do know of attorneys that recommend wills and recommend testamentary trusts because they're building their future business, their future probate business. If I do a will for you today, then when you pass away, your family's probably going to call me. So I'm building my residual income down the road so that I have a practice for years to come. I don't agree with that, but it's done. So be aware of that when you start looking at what to set up. So if you have no death document, if a person passes away without a will, without a trust, without anything, we do what's called an heirship with administration. Heirship with administration is the process of, number one, we have to determine who the heirs are. Who are the heirs? The heirs are family, but it's not all family. It all depends on really what your life looks like. First thing we look at is spouse. Is the person married? Okay, then that's a first heir. If there's not a spouse, then we look for children. If there's not children, then we look for parents. If there's not parents, then we look for brothers and sisters. If there's not brothers and sisters, then we look for nieces and nephews and extended family. I've done heirships where the first person we found alive was like a second cousin. And that's where we start. When you start looking at what level the person is alive at, and that's where it stops. And that's where we determine heirs. Now with an heirship, when we look at, okay, were they married? That's step number one. But then we ask a second question. Were they married and did they have children outside of the marriage? If they didn't, then the spouse inherits. If they did have children outside of the marriage, then the children inherit that deceased person's half of the community property and 2/3 of the person's separate property. So I had a case years ago where a lady came into my office. Her husband passed away. They'd been married 18 years. They had a house together. And I started asking her questions, and I asked, do you all have any children? And she said, no, we didn't have any children together, but he has a daughter from his first marriage who is a real blank. And I said, oh, apparently you and your stepdaughter don't get along. And she says, we can't even be in the same room together. And I said, well, did he have a will? And she says, no, he wanted me to help him do a will some months ago. And I told him, you want a will, you do a will. And I said, well, ma'am, I'm sorry you did that, because by him dying without a will and him having a daughter outside of marriage, that house that you told me you own outright and is worth $250,000, you now own with your stepdaughter, because she just inherited your husband's half of the community property. And she got all uptight, and she was already mad anyway. And she said she inherited $125,000 in equity. And I said, no, ma'am, she inherited ownership into your house. You're now going to be partners in that house. She was livid. And she got up and she stormed out of my office telling me, I'm going to get a second opinion. And I said, well, ma'am, you can get as many opinions as you want. I didn't write the law. I'm just telling you what it is. And she called me back the next day to hire me. And I asked her to please hire somebody else, because some clients are better not to have. So airships can cause major, major problems. Another thing with airships that we have now, because of law changes over the last 5 to 10 years, is when an airship is determined, all of the heirs have to agree on who the administrator is going to be. If they don't agree, we do an airship there's 2 types of administration: independent administration and dependent administration. Independent administration is far easier and far less expensive than dependent administration. But if not all the heirs agree, we have to do dependent administration, which can get into the $10,000, $15,000, $20,000 range very, very easily. So airships are horrible and they're very, very expensive. It is the legal process of determining the heirs and determining there wasn't a will and create a form of an estate plan. Why should you avoid probate? Probate can be expensive. There are court costs, there are publication and bond fees, there are executor fees, attorney's fees, accounting fees, appraisal fees, possibly. It is very time consuming. A probate in Texas, even if everything goes exactly the way you want it to, and there are no people fighting, you're looking at a minimum of 6 months. It is open to the public. This is the process that I hate the most, is if I do your will, you probably don't want anybody to know about it except the people you want to know about it. But when you die, that will gets filed into probate and it becomes public record for the entire world to read. Everybody knows who you left all your stuff to. The second thing a probate does is it requires the executor to file an inventory. The inventory is a list of everything the estate has. So I always said it, if I really don't like my wife and I want to do her harm, I will die with just a will, because now she has to file it for probate. She has to file my will so that my will knows that everything goes to her, and she has to file an inventory, and now the whole world knows everything she has. Who reads public records? Bad people, predators and creditors. So every probate I do, I warn the people, you're going to get a lot of junk mail, but you're also going to get scammed. I had a lady call me one time and say that she got a certified letter. It was in her name, her address, it had outlined everything. And it said, because you owe this money, blah, 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 if you don't send us $2,000, we're going to put a lien on your house. And it was all a scam. And it was all because of all the information they were able to get through the probate records. And so the public aspect of probate is terrible. It opens the door to family members to come in and fight, because the minute you open the courtroom doors, anybody can come in. Creditors can come in, family can come in. They don't even have to spend a dime to do it. They don't have to hire their own attorney. So it causes problems. And again, the inventory appraisal, and sometimes there's multiple probates if you own property in multiple states. So I have people all the time here in the DFW area that have a lake house up in Oklahoma, or they have something in Louisiana, or they have a South Carolina vacation home, or Florida. And if you die with multiple properties in multiple states, you have to do a probate in each state. Now, this slide is a little outdated. It says the typical cost is $4,500. You know, COVID made everything go up. The typical cost today is about $5,500. So what if they have a trust? A living trust, in my opinion, is the best thing a person could ever have. Now, I get calls all the time that say, well, I was told I don't need a trust. And I have to tell people, yep, you're probably right. You don't need a trust, because there are certain people that need a trust. There are people that need a trust if they have a special needs child. There are people that need a trust if they have a lot of money and they need to do tax planning. There are people that need a trust if they have asset protection issues they need to deal with. So there are trusts that are for certain categories of people need a trust, but all the rest of us can benefit from a trust. So you may not need it, but you can definitely benefit from a trust. A living trust is a document that I build for my clients. It is like a treasure chest. So I build this treasure chest, and then we hold your treasure in it. We deed your house into it. We align your accounts with it and your investments with it. We may list the trust as a beneficiary on your retirement accounts. There's all different ways we fill the treasure chest. So I always say, once we got the treasure chest in place, we want it to hold your assets or catch your assets at some point in the future. Now, if you do that right, then as I tell people, I love to tell people I'm not worth one single penny. Because if I don't have an estate and I'm not worth anything financially and I die, is there a need to administer my estate? No, because I don't have an estate. Where is my estate? It's in my living trust. My living trust never gets sick and it never dies. So sickness and death don't affect what's in the living trust. Sickness and death only trigger what the living trust is supposed to do at those points. A living trust does two things I've never had a complaint about. It keeps the government out of your life and it keeps the courts out of your life. And if there's anybody on this call that disagrees with that, you're going to be a first, because we all want to keep the government and the courts out of our life. A living trust does that. It privatizes our life. One of the best phone calls I ever got was from a Forbes magazine reporter. She was calling to ask me questions about a blog that I had written on a guy in Seattle. I think he was an owner of Seattle Supersonics or Seattle Seahawks or somebody, and how he had passed away with a trust. And she asked me some questions, and she said, do you mind if I ask you questions about the blog? And I said, I'll answer what I can. And she said, you know, you talked about him having a trust, blah, blah, blah. I need to know who the beneficiaries are. And I said, well, you don't have a right to know that. And she said, what do you mean I don't have a right to know that? I said, people set up a trust to keep their life private, and whoever the beneficiaries of a trust are, that is not public knowledge. You don't have a right to find that out. And she said, well, I need to know how much money was in the estate. I said, well, you don't have a right to know that either. And she asked me about 5 questions that I told her she didn't have a right to know. And she was so angry, she almost hung up on me. And I got off the phone thinking, that's exactly why I do living trust for my clients, because it's nobody's business what you have, who you're giving it to, or what you're doing. A living trust keeps your life private. So it is a wonderful, wonderful mechanism that, to me, it's one of the best treats you could ever give your family, is you setting up a living trust for the family. Now, when a person dies with a trust, the misconception is that nothing needs to be done. Well, you're avoiding probate. Well, that's right. A trust avoids probate, but a trust still needs to be administered. We still need to carry out what the trust says when somebody dies. So that takes place in a lawyer's office. You go to an estate planning attorney that does trust administration, and they will walk you through the process of what needs to be done. And people will always ask me, well, what does that cost? It depends, because it depends on what the trust says. The more complicated the trust is, the more expensive trust administration is. So when you set up the trust, you have a lot of options. A trust is like a custom-built house. I can add rooms, I can leave rooms off, but as you add rooms, that makes trust administration a little bit more complicated. But it builds in protections, so there's pros and cons. So when a trust, when a person dies, the trust administration takes place in the privacy of a law office, and it takes a matter of days, usually, rather than a matter of months. The only time a trust administration will take longer is if you're filthy, filthy rich. So if you've got a lot of money and you've got an estate tax problem, typically we have to go through the process of filing estate tax returns and all that kind of stuff. And that can take up to a year, depending on what that is. But if it's done right, you can save a lot of money. I had an estate worth about $26 million. The cost of trust administration wasn't cheap by any means, and it took a long time, but we saved the family about $2.7 million in taxes. So it's very important for the wealthy to have things like this. But for simple trusts like mine, I don't have that much money. It's usually a short process. It's a matter of doing paperwork. It's a matter of maybe moving some bank accounts and getting things set up. But again, it's all done privately with just you and your attorney. So that's not all. You know, when we look at the legal process, we look at right after funeral and stuff, but what other things might we need to think about? We need to think about utility companies. Think about somebody in your family. Think about your parents. Do you know who their electric company is, or their gas company, or their cable company, or their internet company? So a lot of times there are multiple choices within a community of who you can choose. There's not just one. And so knowing what they have makes it a lot easier to deal with it. What about the post office? And do we need to forward the mail? I get that all the time. Can I legally forward my parents' mail over to me yet? Or do I have to wait for the court? Or what do I need to do? Financial institutions, insurance companies, was there insurance? Is there life insurance? Do we need to file for that? What needs to be done? What about the mortgage company? Who's the mortgage company on mom's house? And what do they need to, how do we pay them? A lot of times today, it's great because we can do a lot of things online. But what that does to a death is if the family is not involved in the online payments, then they don't know who to deal with, because we don't get mail anymore. We don't get mail from the mortgage company. So I've had people just completely freaking out because they're like, I have no idea who my mom pays her mortgage payments to because she does it all online and I don't have access to her online banking. And so what do we have to wait for? Typically, we have to wait for it to get late, and then they'll start doing mail because they'll mail letters saying you haven't paid in 2 months. And by that time, you know, we're behind. So again, the more organized you are, the better you can do for your family. And if you're dealing with parents, trying to talk to your parents about getting organized, and the generation before mine is very, very, very secretive. Trying to get that information out is sometimes difficult, but it makes the family's life so much easier if you know all these things on this page before the person passes away. Ultimately, it does come down to the fact that whenever you administer an estate, you've got to determine some things, but you need to gather all of the assets and the debts. You have to pay the decedent's debts, but not all of them, depends on what it is, and you distribute anything that's left. Now, when it comes to debts, I tell people that if the estate has to go through administration, there are certain debts you don't pay until we absolutely have to pay them. Now, there is a process when you go through the probate process that creditors have to file claims against the estate. If they don't file a claim within a certain amount of time, they lose. They lose out on their right to even collect. So I tell my clients all the time, until we get through this process, I want you to pay 2 categories of debts. I want you to pay anything that will be taken away, like a house or a car, or anything that will be turned off, like utilities. Anything other than that, we don't pay. We're not going to pay credit cards. We're not going to pay medical expenses. We're not going to pay any personal loan that's not guaranteed with something. We're going to put them on notice that the person passed away, and then it's their responsibility to file a claim. If they file a claim, then we have to accept it or reject it, and we go through the process. But things get put into categories. So even once the claims have come in, the courts have said these get paid first and these come down to the line. So like credit card and medical payments are 9, 10 on the list. They're way down at the bottom. The number one expense that gets paid, funeral expenses. Number 2 expenses, taxes. The government's going to get their piece. Number three, you can tell who wrote the laws, legal expenses. And then we go down the line from there. So debts, it all depends on what they are. And one of the things I tell people all the time, you are not responsible for your family's debts, including your spouse. In Texas, we are a community property state, but we are not a community debt state. So if my wife has a credit card in her name only and she passes away, I'm not legally responsible for paying that credit card. Only her estate is legally responsible. So depending on how that goes in administration, her estate may or may not have any money. And so quite often I put creditors on notice that an estate is insolvent, meaning it does not have money to pay debts. And if you do a trust doesn't go through the courts. So there is no open door for the creditors to even come in. And the creditors have to initiate their own lawsuit if they want to go after somebody with a trust. So I don't want to get too deep into it, but again, a trust is the best thing you could ever set up for you and your family. Now, I have talked a long time, even after screwing up and having the wrong slides, and I apologize. I think today is the fourth Monday of the week, apparently. But thank you guys for putting up with it. Thank you for listening. I hope you did get something out of it. But now we want to open the door. I'm going to turn it back over to Sheila and let us know what questions we have, Sheila.
Okay. Well, okay. First one is from Monica, who wants to know, can you tell us how long it typically takes to get copies of death certificates?
I have been told typically it's about 30 days. I think it depends again on the state. And quite often, I think it depends on what county you're in, because I think they usually typically go through the county clerk's office.
Okay. Monica would like to know, can you repeat what you said about the cars being outside of probate?
No, I can't. No, I'm just kidding. Just kidding.
Yes, you will.
So again, I just want to clarify this, that I'm talking about Texas law. So if you live in another state, it may be different and you need to find out. But in Texas, the Department of Motor Vehicles, which is different than the tax office, which is different than where you get your registrations, it is the actual DMV. The Department of Motor Vehicles has a process whereby you can transfer a vehicle outside of probate with a death certificate and their affidavit of heirship. So they have a form that you fill out and it transfers over to the heirs. And so you can transfer a car. I've never had anybody have a problem with a vehicle to transfer it outside of probate. But again, you go through the Department of Motor Vehicles to do that.
Okay. The next one is from, I'm going to pronounce this, Caitlin. Mail service was a huge challenge for me. I had to be able to present the letter testamentary to the post office before I could forward my mom's mail. It took 6 months before I had it. Is there any way to do this without having to do a letter testamentary from the court?
I have been told, again, this one I don't have firsthand knowledge, but there is a way to get online and do a forwarding address. And when you do a forwarding address online, it asks the questions. And if you can answer those questions, they don't require proof. So I have had families get online and forward it to their address. And it's in essence, you're not telling the Postal Service the person passed away. All you're doing is filling out a forwarding address saying, I want the mail to go from this address to this address. And so that one I would recommend families to do when there's not fighting. When there's any type of family discord, I don't want my families doing anything before we go to court.
Okay. Liza wants to know, what if the person is on the bank account, but it's not a joint account?
Okay. That's a big issue. Thank you for asking that, because the banks make the rules. And the banks set up the accounts the way they want them to set up. And I've had people think they were joint owners with their account. So like, I'm on my mom's account. I'm a joint owner. And so I think I'm a joint owner of her account. And then all of a sudden she passes away and I realized that all I am is a signer on her account. I have the authority to sign her checks and pay her bills, but I'm not a co-owner on that account. Then that account gets frozen and it has to go through probate. So I always tell my clients all the time, you need to go to the bank and make sure that the account is set up exactly the way you think it is set up, because it requires their paperwork to make sure that's done right.
Okay, Liza also wants you to clarify, and I understand this because we get this question all the time. In Texas, why can the spouse automatically not get the house if even if the other name is not on the deed?
Okay, so let me think. So mom's name is the only one on the deed and dad dies. Is that what we're saying?
I guess so, yeah.
Then
She said spouse, so yeah.
then is the house automatically mom's? It is if it's not community property. So community property and separate property are determined by when it is acquired and who it's acquired by, not whose name is on the deed. So and I've had this happen to where husband and wife bought a house, but husband didn't have good credit because he had problems or he went through a divorce or whatever. And wife has good credit. So they buy the house and they put wife's name on it, and wife is on the deed and wife is on the mortgage, but they're both buying it together. Husband put money in, they're both paying the mortgage. It's community property, even if mom's name is the only one on there. So it's the determination of what the classification of property it is that determines whether or not mom can just take it or not. So if it's different though, let's say mom brought it into the marriage. It was mom's house before they ever got married. Then it is mom's sole and separate property. Now, even if husband made payments on it, he may be, or his estate may have a right for reimbursement, but it doesn't change the ownership of the property. The ownership is still mom's sole property. In that case, it is mom's house and it doesn't have to go through probate. She owns it and she keeps it. So it really depends on how it's classified. Quite often it depends on whether family is fighting over it and what the big deal is out there. So it really depends on that.
This is why you need an attorney to do
Oh,
this.
you know, in Texas, you cannot go through the probate process on your own. So they passed laws some years ago that said every person has to hire an attorney to go through the probate process. I've had a lot of people upset about that, and I understand why. But at the same time, there is so many intricacies and so many problems that happen. That's why the law went into effect, is people and probate judges got tired of people coming into court not knowing what they were doing, and it made it a mess. So you have to hire an attorney. Now, I can't recommend enough, don't just hire an attorney. Hire a probate attorney, because probate is different than any other aspect of the law. I wouldn't dare do somebody's divorce. I'm not a family law attorney. I will just do probate. So hire an attorney that does what you're needing them to do.
Okay, Melinda wants to know, how long does it take for the probate process to get started and get on the court docket?
Well, it gets started based on you. So when my clients call me, sometimes I've had my clients call me the day the person died. And I have to tell them, slow down, get through the funeral. You guys take care of what needs to be done from the family and then call me back and we'll get started. And so once we get started, I gather information from my clients, I draft documents, and we file them with the court. Once they're filed, then we have a 10-day, what's called a publication of citation process. So we have to wait 10 days. And then we can reach out to the court to try to get a hearing date. The length of time depends on how busy the court is. During COVID, it was an absolute nightmare. We wouldn't get hearings for months. Now it's better. And so we're getting hearings faster now, but also it depends on the county and the judges. I hate to badmouth any county, that there is a certain county with a big giant city in it that loves to root for the Cowboys. That is a county you want to stay away from because it is a nightmare in getting in and getting a hearing and the length of time it takes. I have cases in that county that have dragged on for years. So there are a lot of things that play into that. That's why I can't emphasize enough how important it is to set up an estate plan that avoids probate because there's so many unknowns.
Okay. Now, Melinda has another question. Is heirship based on the firstborn child outside of the marriage? So if there are several children, but different mothers, how is this done?
Okay, so dad dies. Dad had children of this marriage that he was in when he died, and dad has children from several other women. The court doesn't care. The court looks at, did dad have children outside of the marriage? Any at all? He can have one outside the marriage. He can have 50 outside the marriage. The minute we find a child outside of the marriage, that changes the whole complex of the thing. And it says that the children, all of them, both inside the marriage and outside of the marriage, and from multiple women, all of the children inherit dad's half of the community property and 2/3 of dad's separate property, and they divide it. So if there's 3 kids, they each get 1/3 of dad's stuff. If there's 50 kids, they get 1/50th of dad's stuff. So it really doesn't matter. Part of that process of heirship, and that's why it gets long and expensive, is finding all these kids. I've had cases where, well, we know dad was a player and we know dad had kids outside of the marriage, but now we got to find them. I've got a case not too long ago that she says, well, I think I had 2 other brothers, that people talked about them during our life, but I don't know who they are. Well, if we have to do an heirship, we're going to have to find these 2 boys, and we're going to have to probably do a paternity test to see if they are truly dad's kids. And so it gets messy. It gets really, really messy.
Okay, Caitlin has a comment, and everybody's going to like this, and you can comment on this. She said, I've heard that executors of the estate don't need to pay credit cards off, but that was not the case for me during the probate. American Express was very persistent, to put it mildly, and medical debt collectors were also very aggressive. What would you tell them in regard to this?
I would tell them that they need an attorney and that the attorney should handle that. So when I have cases involving that, where we have aggressive debt collectors, I can't stop the debt collectors from calling the people. I can't stop them from sending multiple notices, but I can send them the notices, putting them on notice, telling them that there's a death, that there's an administration, and that they have to file a claim. Now, if they do not file a claim within the set amount of time, I can now threaten them that if they don't back off, that we're going to go after them. And typically that works. American Express is one of the most aggressive of all the credit cards, but they still have to go through the motions. They still have to file a claim. They still have to go through. So I don't want to get too in depth, but if a creditor files a claim, the executor has to do one of 3 things: accept it, deny it, or ignore it. If you ignore it, in 30 days, it's automatically denied. Now, from the date of denial, the creditor has 90 days to file a lawsuit into the court. If they do not file that lawsuit, they lose. If they do file that lawsuit, then we need to deal with it. Now, if we deal with it, what do? We look at the estate, we look at the money in the estate, and we determine what needs to get paid and if there's even any money to pay it. So they don't get moved up on the list. They're still a credit card company. They're still 9 or 10 on the list. The court sometimes steps in, and often we have to do a dependent administration at that point. And the court helps us determine who gets paid and from what money. But again, money never, ever, ever should come out of the pockets of family members. You're not responsible for paying the estate's debt. And if you did, I'm sorry, because you shouldn't have, and you should have gotten better advice. but that's the gist of it.
Okay. In that same vein, Texas is not a community debt state. What if a spouse dies owing the IRS? Is the surviving spouse responsible for the unpaid taxes if it was not a joint filing return? Boy, that's a good one.
Typically not, no. Typically, only the deceased spouse's estate is responsible for an IRS debt that is owed by the only the deceased spouse. I've had a couple of those, and we had to put IRS on notice, and they filed a claim, and they did all this stuff. And then once it was determined that the estate didn't have the money, they didn't even try to go after the spouse. So no, that's typically the way it happens.
Well, that's good. That's good information. Okay, Monica says,
But let me clarify that.
Okay.
If the IRS could attach it to the a spouse in any way, shape, or form, they will. So again, even though you file separately, doesn't mean the IRS can come back and claim, no, that isn't just his debt, it's both the debts, and then you have to file that. And there are cases like that where we go beyond a probate process and we need a tax attorney involved. And the tax attorney has to deal with the IRS, because I don't deal with IRS issues like that. I hire another attorney to help me with that.
okay, Monica wants to know, I'm sorry if you've already said this. Do you need a trust and a will?
No, that's a very good question. When a person does a living trust, they get a will with it, but it's a special will called a pour-over will. And the pour-over will simply says, I have a trust. I want everything I have to be in the trust. And if I forgot to put something in the trust and I die, I want that asset to pour into the trust. So the pour-over will is never probated unless the person forgot to put something in their trust. It's kind of a safety net in case we messed up and left something out of the trust.
Okay, Mary wants to know, what is the best form? This is what the question says. What's the best form for saying where the minor children need to be placed?
Okay, well, thank you, because I kind of alluded to that with the will. We do a separate document that is a document for appointing a guardian, but even that one has to go through court. The best way is to do a trust. You have a trust, and within the trust, it says who the guardians are. And again, the trust is not dependent on court intervention or court approval. If the trust says, I want my sister to be the guardian of my children, then my sister becomes guardian of the children immediately. And now, yes, she might have to go through court to finalize that and get the legal conservatorship and do the things that she needs to for the schools and everybody else, but she immediately is in charge. So a trust is the best way to avoid child protective service intervention or court intervention.
Okay. Anonymous wants to know, what is a ladybird deed?
Oh, ladybird deed is a special deed. Not every state allows it. I don't know, I can't remember the number of states that do. But a ladybird deed is a special deed that says, I own my house while I'm alive. I have what's called a life estate. I get to use my house. I get to live in my house. I can even sell my house if I want to. But the minute I die, it passes to somebody else. So it is a way to pass your house outside of probate without using a trust. So I do ladybird deeds quite often. If a person has more assets than just the house, then we talk about doing a trust instead. A trust is still a better mechanism. But a ladybird deed is often used in Medicaid planning. So if mom needs to go into a nursing home and is going to be on Medicaid, Medicaid can attach a lien to the house, but they cannot attach the lien until after mom dies. So a ladybird deed is really a legal loophole to pass the house outside of Medicaid so that it passes to family members and Medicaid can't attach to it. And it's perfectly legal. So yes, ladybird deed's a good mechanism. We use it quite often.
Okay, another anonymous question. I am divorced, home in my own name. How do my sons know where my accounts are and my passwords?
How about telling them? I mean, I don't know what else to tell you. either tell them or have it somewhere where they can find it. So when my clients do documents, quite often I recommend we use a company called DocuBank. DocuBank is an online storage of documents, and you can look online, just Google DocuBank, DocuBank. And DocuBank has two ways of storing documents. They have the DocuBank Healthcare and DocuSafe. And DocuBank Healthcare allows us to upload our forms that a hospital would need. So I upload my medical power of attorney, my HIPAA form, my medical directive, and DocuBank sends me a credit card that I carry in my wallet. And it says in case of an emergency, and it tells the medical professionals how to download those forms. It also gives them other medical information about me, and it gives them a contact people of who I want called if I'm in a car wreck and taken to the hospital. DocuSafe allows us to upload anything else. We can upload a trust, we can upload our wills, we can upload anything that we want. And it's like online banking. You get a username and password. A lot of my clients will do DocuBank, and then they just say, when I die, the information for DocuBank is in a folder in my house or in my safe or in the freezer. A lot of people will store their important documents in the freezer. And then when I die, that's where you'll find it, and it'll give you access to DocuBank, and then you'll have access to everything. But one way or another, you need to make sure that your children know where they can get the information.
Okay, JB wants to know, how much does it generally cost to set up a trust?
Okay, that's a very good question. Again, it depends on the attorneys you use, but this is one of those areas you get what you pay for. So the cheaper you go, the more likely you're not going to get a good product. That's the reality. We have attorneys out there that are doing trusts that shouldn't be doing trusts. So if you go to an estate planning attorney that knows what they're doing, you'll typically look for a single person, $2,500 to $7,500. And for a married couple, $3,500 to $9,500. So it all depends on how you build it and what all it has. But again, the more like a custom built house, when I add on a media room, and when I add on a den, and when I add on a game room, it gets more expensive. And in trust terms, the media room, the game room are extra benefits. So I can add, for instance, I can add within a person's trust a second trust for the children, so that when the mom and dad die, the assets go from their trust to their children's trust, called a heritage trust. And that heritage trust has asset protection to protect the inheritance from lawsuits, creditors, bankruptcy, and divorce. You add that trust, it gets more expensive. So that just gives you kind of a ballpark what to expect.
Okay, Monica asked, when you put your house in a trust to be given to your children, does it save them money on paying property taxes?
Doesn't really affect property taxes at all. It doesn't have a tax benefit or a tax detriment.
Okay. Elena wants to know, if all heirs don't agree on the affidavit of heirship, what other document or process must be done?
So an affidavit of heirship, if the heirs are not in agreement, you almost always have to go through an heirship proceeding in court. And it typically is an heirship with dependent administration, which again is very, very expensive. But that's the bad thing about an heirship of any kind, is people have to cooperate and get along. And if they don't, which a lot of families, I would hate to say majority of families, but a lot of families have problems. You have one problem child or whatever that makes it horrible on everybody else.
Okay.
So I always tell people, when families fight, you get to have attorneys involved. And the more families fight, the more the attorneys win, because the attorneys are the only one that wins when families fight.
Okay. If a vehicle is jointly owned by a couple, is there a benefit for transferring the title to just the surviving spouse?
I would say that's a question for the DMV, but I'm not sure about that, if there's a benefit or not.
Okay. Does it affect retirement accounts when put into a trust?
Now, let me back up to the vehicle question, because of course, as I pass it and I start thinking, if the deceased person's name is still on the title of the vehicle, and you haven't transferred it just to the survivor, you're going to have trouble when you sell it. So it's better to get it in the person's name that's alive, because if you tried to sell or trade in that car, there would be a problem. Now back to the retirement question again, Sheila.
Does it affect retirement accounts when you put them into a trust?
So retirement accounts don't go into a trust. There's the state laws usually are more beneficial than putting it into a trust. So with our retirement accounts, I tell my spouse, my clients, you want to typically list the spouse as the #1 beneficiary, because the spouse has the exact same powers and duties and protections as the person that owns it. And then you name the trust as a contingent beneficiary or secondary beneficiary. So you want it to flow down to the trust before it flows, instead of it flowing to your children. Because if it flows to children, children can get sick and children can die, and sickness and death cause problems. A trust doesn't. So it flows to the trust for the benefit of the children.
Shannon wants to, this is interesting. I have families who are worried about paying their deceased loved ones' utility bills and rent with that individual's money. For example, using their credit card to pay once the individual passes. Are there issues with this we should be aware of?
I'm not sure I know, I understand that question totally.
I think she means before, my guess is before the probate is done, before the estate is administered.
So I mean, I quite often tell my clients, again, if you don't want things turned off, somebody's going to have to pay it. And if you don't have access to mom's accounts because we're waiting for probate, then you're going to have to pay out of pocket, and then you have a right for reimbursement once we get the estate open. So if there's a concern that there's not money there, then you have to decide, am I going to pay it and I'm not going to get reimbursed, or are we going to stop paying it and let them get turned off? That is a hard question to answer as just a general question. That's typically a case-by-case type of question that I have to walk the clients through depending on what their situation is.
Okay. Oh, this is interesting. I have a relative who is an immigrant. She now has a permanent green card, but was not on the original purchase of the home in Texas, nor vehicles that she and her husband have. Would you recommend a trust also in this case?
Yes, I can do trust for people even that are not citizens. And I need to know that because there's tax issues that need to be taken into consideration.
Okay. Now, this is a good one. What is the difference between a ladybird deed and a transfer on death deed?
Not a whole lot, except that the transfer on death deed is a new law. It hasn't been in effect a long time. And the whole intention of a transfer on death deed was to keep it out of probate between husband and wife. So the intention of the law is so that my wife and I can do a transfer on death deed between each other. And that way, when one of us dies, it's the survivors. People are using it for other purposes, and it wasn't meant for other purposes. So I don't recommend transfer on death deeds. And the reason I don't is because I don't know how the title companies will treat them in the future. I'll give you a perfect example. Everybody has probably heard of a quitclaim or a quitclaim deed. Some states do a lot of quitclaim deeds. A quitclaim deed, in essence, is giving away my interest in property. I'm quitclaiming, I'm giving my interest away to whoever. Texas law allows quitclaim deeds, but not one Texas title company I've ever dealt with will accept a quitclaim deed. They do not honor them because the law is too vague and they're not comfortable with them. And the reason is because title companies are insurance companies, and they have to underwrite and insure title to a house. And if they're uncomfortable about anything, they can deny coverage. They can deny insuring it, which that's their rules. I'm afraid we might see that in the future with transfer on death deeds because of the law is not written well. The law has a lot of vagueness in it. It has a lot of uncertainty in it, a lot of unanswered questions in it. So that's the purpose of the transfer on death deed and the Lady Bird deed, very, very similar.
Okay. Do you have any advice regarding inherited IRAs for non-spouses?
So retirement accounts used to be the best inheritance you could ever leave your children. It is now the worst. And that is because of law changes in 2013, 2017, and 2020. The worst one in 2020, called the Secure Act, now says that when my children inherit my money, they lose all asset protection to it. So it can be taken from them by lawsuits, creditors, bankruptcy, or divorce. And they have a maximum of 10 years to pull it all out. Now, when they pull it out, it is added to their income. So let's say my daughter makes $150,000 a year. Her and her husband make $150,000 a year. They're in whatever tax bracket that is. Let's just assume it's 22%. Let's say I've left them $1 million, meaning they have to pull out at minimum $100,000 a year. So that $100,000 is added to their $150,000. Now their income is $250,000. That may bump them up to the 30% tax bracket, and they're taxed at 30% for all of their money, not just the money they inherited from me. So it is a horrible tax detriment to children if it's not planned right. So I often tell my clients, you need to, if you're young enough still and you have a lot of retirement money, you need to start working with a financial planner to try to figure out how much of that money am I going to live on? Because retirement money was for retirement. It wasn't for inheritance. How much am I going to retire on, and how much can I pull out and move to other investments that are better passed on as inheritance than retirement money? So with people with a lot of money and they're up in age, I've got clients in their 70s and they have, $2-3 million in IRAs. There's no way they'll use all of it. It'll definitely have to pass down. We can build what's called a retirement plan trust that gives some protections back. So there are options depending on where you are in the process, but not very often can I say that I understand why the government did what they did. But in this situation, I don't agree with it, but I understand it. The government was never getting their money on retirement accounts. It kept passing down to generation. And so the government said that wasn't why retirement accounts were set up. They were set up for people's retirement. And so that's why they passed these laws to make it, discourage it as an inheritance and keep people using it. So again, this is one of those things I highly recommend people talk to a trusted financial advisor about their retirement accounts.
Okay. All right. One more on this page, and I think Marty then has something to say. Okay, Fred, would you pull your DocuBank card out of your wallet?
I don't think
You don't
I
have
have it. Let me look.
It says, this person says, can you tell me more about it's not DocuMate, it's DocuBank and DocuSafe. When I look up DocuSafe, I see an app for DV survivors that is being discontinued. What is
No,
the card you can carry in your wallet with the link to your planning docs? You don't
Yeah,
have it with you?
I don't have it with me, but it's
Okay.
DocuBank.
Okay.
And once, DocuBank has those two, it may not even be called DocuSafe. I call it DocuSafe, but it's a storage for any documents other than your healthcare.
And I'll get Fred, if you or Sheila can send me the link to that, I can surely include that in the follow-up email.
Yeah.
That would be great. Real
Okay.
quick, I know it's right at time, and so I want to make
Yes.
sure I go over the CEUs for people that have to get off. Fred, I'm sorry, I don't mean to interrupt you. I just want to make sure we catch
No,
up.
I know we're out of time.
Okay. Hey, for those of you that are joining us for CEUs today, we're offering CEUs for licensed social workers and licensed professional counselors in the state of Texas. Please note that if you have a license outside of Texas or you have a different license in Texas, you're more than welcome to go through the process and get a certificate, submit it to the jurisdiction. Again, there's no guarantee that they'll take it. These are who we're set up with. But I have been contacted by jurisdictions before asking me for some more information about a particular webinar to see if they would accept that. So there's that, and there's also certificate of attendance for anybody who's interested. The guidelines are the same for both. Today's webinar is worth 1.5 hours of CEU credits. You must have completed the entire live webinar and the Q&A, and at least stay with us until 11:30. You must complete the Google evaluation survey as well. That should, when you close out from Zoom, it should say, would you like to take a short survey? That will send you to the Google survey. If not, no worries. I will be emailing those that out in the follow-up email to everybody that's on the email today. I'm sorry, on the presentation today. There's a difference between on the presentation and registered for the presentation. We always have about twice as many people register that come on. The first follow-up email does not go to the registered. It goes to just the people that attended. There's a second follow-up email that doesn't have the CEU information, but it does have the link to the webinar recording. And that goes out in the second follow-up email, and that goes out to everyone who registered for today's event. Please, the survey, if you don't take it as you close out of Zoom today, you'll get the link in the follow-up email, the first follow-up email. You must complete it by 5 p.m. on August 2nd, which is a week from tomorrow. And then give me until September 2nd to get those certificates out to you. Fred, that's all I had to jump in for. I don't know if Sheila, was there anything else, or you guys?
There's a couple of things I would like. One thing is I've had 3 or 4 people ask the same thing, and that is, and we have this every time, if you don't have that kind of money to set up a trust, what would you suggest? And I was going to say Marty has resources that he could put in here on a follow-up for people. Legal Aid is the only one I know of, but Marty, you do have resources like that.
There's the Legal Aid and there's the Texas State Legal Center. Both of them do some stuff. I do know the Texas State Legal Center does, I believe, both the Lady Bird deeds and the quitclaim deeds, but I'm not sure how much they'll do in regards to setting up a trust. But I will include the nonprofit legal centers in my follow-up email as well. Once again, please note that doesn't mean they actually will work on trusts. I don't know which ones do and don't. Yeah, the other thing is you might also check with your local bar association. I know that the local bar associations usually have a somewhat of a bank of attorneys that belong to that have provided a certain amount of pro bono hours or something like that they might work with. But again, that's for people that really can't afford it. So they're going to ask the questions if you can afford it, and if you can't afford it, you're going to need to go through an attorney that charges to do that.
Yes.
So let me add to that. If it's just a matter of a trust is too expensive, at least do a will. At least do a will in your living documents. Typically, that's less expensive, and most attorneys can do those. Also, and I don't want to plug there's a what is it called? Prepaid legal. There's some companies offer it, but I think you get it on your own where you pay $50 a month or whatever, and you get certain legal services. I've heard that they will do simple wills and simple stuff like that, and that's better than nothing. So at least try to do a will and power of attorney, medical power of attorney, those kind of documents. We even have a package in our office that I call a college student protection plan and a senior citizen protection plan that are the simplest of documents for those 2 categories that don't need a trust and don't need all the complicated stuff. So most attorneys will have something like that. So you at least get something in place. Anything's better than the government deciding your fate.
And yes, the
Go ahead.
itemized list that people keep asking about, I've seen it several times, that will definitely go out in the follow-up email.
And some of the things on the list, I'm gonna be honest with you, some of the things are, you would think are self-explanatory, like ordering death certificates, etc. But then there's other things that are not. And this is very important because I know that I've been through the death of both my parents and all kinds of things. And when I saw that list, there's a lot of things that I didn't know. So
Well,
it's just helpful, trust me on this, it's helpful to have that.
and
So,
it's also important because when you're not in the right state of mind, especially
yeah,
when you're dealing with a sudden death that was unexpected, many times you're not in the right frame of mind and you don't think of the things that normally you would think would just be at the top of your head. So it's really, really a good piece to have.
Well, let me finish with that, Marty, because one of the things that I've been told by pre-need funeral people like Dignity Memorial and others that do that they're very much like us attorneys. They make a lot more money after the fact than they do before the fact. I always tell people I make a lot more money cleaning up messes than I do doing it right, and they're the same way because when you're acting on emotion, you will always spend more money, always. And so that is why I can't encourage people enough. The more you do pre-planning when you're in a state of mind to be rational and think about things, you're going to save your family money. You're going to save them headaches and stress and anxiety, all of that. So please consider it.
and you know, it goes along with Marty and I've talked about this at length. It goes along with, there's a lot of people, when they hear this topic or they hear the one about the pre-need funeral, they're like, oh no, I don't need that now. Yes, you do. Yes,
You
you
have
do.
you have no idea when you're going to need it, and that's just going to happen someday.
It
And
is.
everyone is going to need it. It is absolutely right. It is just going to happen. And for you to not have planned and that to fall on your family, especially in a sudden death situation, unexpected death situation, that think about how hard that would be for you to do if someone left that on you, and how much help it would be have you taking care of a lot of that stuff so that they are not having to deal with that in the midst of their grief. It's just really think putting them, I guess putting them first is I don't know how else to say it, but
Yes.
you said something about the death certificates, the certified death certificates. I do know that when my dad passed away, and we were in California, so we didn't know how many to get. The problem was, I don't know in Texas, California, the funeral home provided you, I think it was 3 copies as part of the thing, but then we had to pay
Oh,
like
shit.
$20 a copy for each additional certified copy. So you do kind of want, if you have an idea of how many you're going to need, and I don't know, and I don't know, I think we needed 7 or 8 at the end of the day, but you don't want to be paying $20 a copy. But then when you go back later, it takes a god awful amount of time to order more to
Right.
get additional ones. It's a little, and I think it was more expensive later. So having some kind of idea would be helpful. And maybe you guys have a suggestion for that.
No, I agree with you 100%. You know, quite often I'll walk through my clients and say, okay, how many do you think you'll need? And well, I don't know. I think you need 5 to 10. Well, then just get 10. You know, I know it's a little bit more expensive, but I'd rather you have 10 and not, because going back after the fact it's a pain.
Yeah.
And it is
So-
more money. You are correct.
And I think it costs more money later. And so it's just hard. I mean, I realize that's a hard issue, and you know, it maybe, and I know this is for another time, but maybe, you know, at some point in time we could do something on what you would need them for. You know, and what are the different things? In other words, how do you
That's a good
determine how many
idea.
you're gonna need? It kind of determines what things you know, who's going to require them, and that kind of helps you come to at least a minimum of a number of what you need. But we could handle that at a different day.
Marty, that's a good idea. That's a good idea. We have not done that.
Well, thank you
I
all
will
very
tell you that we talked about this. We did this topic, like Fred alluded to the other day, for a lunch and learn, which was packed. Okay, and that's why we decided to do the same thing here, because we knew it was so sought after. This presentation was so sought after. We talked about doing a part 2. And the part 2 is what either the executor or the trustee has to do in the beginning, and how this is going to look to administer the estate and the death certificate. See, that's part of it. I think we're already thinking about that. That is because if you don't know and suddenly you're thrown into this role, I mean, sometimes you do know, maybe I don't mean to be rude, but maybe the person has had cancer for a long time and you know that they're on hospice and this day is coming. But perhaps they were in an accident or, heaven forbid, just pass away in their sleep or whatever. Well, then you're thrown into this role and you have no idea. So I think we've already been talking about doing a part 2 to this, as to what comes next and an order of things that have to be done, because it scares people. And if you knew what was required of you, like the death certificates, what you're going to have to do with them. Okay, why do I need those? How many do I need? What do I do with them when I get them? And blah, blah, blah. Okay. And, I think we're already thinking about that. So maybe that's already on our radar to come up with, but that is a brand new presentation that Fred will have to write. So,
Well, Sheila, I'm gonna ask that we wrap this up because
Yes.
I've got a client waiting on me.
okay.
Thank you. Thank you both very much. Thank you, thank you, thank you. We certainly appreciate it. And thank you all for joining us, and you all have a wonderful day.
Thank you, Marty.
Thank
God
you
bless
for
you
your
all.
patience.
Bye,
Bye-bye.
y'all.